Hello, everybody. It's Walter, your favorite historian, educator, professor, and social studies extraordinaire, here today to give you a brief overview of the Fourth Amendment to the United States Constitution. The Fourth Amendment to the Constitution is one of the most important safeguards that the American people have against unlawful law enforcement practices. Specifically, the Fourth Amendment protects persons and their property from unreasonable searches and seizures by law enforcement. In addition to requiring warrants to typically seize and search persons and property, the amendment sets out clear guidelines for the issuance of those warrants. For a warrant to be issued by a judge or magistrate or some other important official in that category, warrants must be supported by probable cause, as well as an oath or affirmation, and they have to specifically list the place to be searched and the things or persons to be seized. Okay? So, before I go any further, I'd like to issue my disclaimer that I am not an attorney at law. None of the information contained in this video is to be construed as legal advice, ladies and gentlemen. All of the information contained in this video is to be used strictly for educational and procedural purposes, not legal advice. Any questions regarding the legality of a law enforcement search or seizure should be directed to an attorney at law. Thank you very much. So the text of the Fourth Amendment is as follows. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So with that language, you can see that the Fourth Amendment serves a very vital role in protecting and securing both the persons and the property of the American people. So one way that the Fourth Amendment is enforced is through the exclusionary rule. The exclusionary rule is not in the Constitution. It is a judicially created prophylactic rule that bars illegally obtained evidence from being used against the person from whom it was seized. Okay? Again, that law, rather that rule, was created by the Supreme Court. All right, initially in the case of Weeks versus United States in 1914. It barred the use of illegally obtained evidence in that circumstance from a wiretap. All right? However, in the Weeks decision, that case only made the exclusionary rule at that time applicable to the federal government. All right? A wiretap used by federal agents. Therefore, the states were still free to flout the Fourth Amendment as they saw fit. It would not be until 47 years later, in the case of Matt versus Ohio in 1961, that the Supreme Court, through the 14th Amendment, would apply the Fourth Amendment's exclusionary rule to the states, thereby making it equally applicable to both the federal government and the states. And once again, the functionary role of the exclusionary rule is to bar the usage of illegally obtained evidence from being used against the person from whom it was seized. It is the essential way that the Fourth Amendment to the Constitution, in the text that we just read, is enforced. Okay? There has to be a way to enforce an amendment to give it teeth. Without a mechanism of enforcement, the amendment is nothing more than a paper tiger. Okay? Now, as the Supreme Court grew more conservative in the 1970s and 1980s, the court adopted a lot of exceptions to the warrant requirement. All right? Ways to somewhat get around the need for a warrant to search and seize things. All right? Essential exceptions, okay, to the exclusionary rule. All right? And they are as follows. The consent search, the plain view, all right, the car exception, the inevitable discovery, the good faith exception, and the exigent circumstance exception. I'll touch on each of these, just give you a little overview of how they function. And again, this is to give you the basics so that you can go forth and do your own research and learn about the cases and circumstances which led to all of these exceptions. So the first one is the consent search. as it suggests, you are willingly consenting to a law enforcement official's request to search yourself or your property. Whatever they find is fair game, folks. So, there's no backtracking on that, all right? So, if you agree to a consent search, you are letting a law enforcement official search your person or your property. And whatever they should happen to find may well be used against you in a court of law. All right? One person told me a long time ago that only a pure D fool would agree to a law enforcement consent search. And I can't exactly disagree with that statement. All right? So, it takes us to the next one. The plain view exception. When a piece of unlawful property or unlawful substance or whatever the case may be is in plain view of law enforcement, they don't need a warrant. It's right there. They're able to take that and place you potentially under arrest. All right. In the consent search, obviously, you do not need a warrant. Either you are giving them permission. You're saying to hell with the Fourth Amendment. No warrant is needed. Search me. All right. Plain view. It's right there in front of the officer's face. A warrant is not required. All right. They can take that and, again, potentially place you under arrest. Okay. The vehicle exception, which goes back to 1925. All right. This allows law enforcement to search vehicles with probable cause if they believe that you yourself have something illegal on you. All right. Or they have reasonable probable cause to believe that contraband is in that vehicle. Obviously, there's an exception to the warrant because evidence could be destroyed. It's almost impossible to go get a warrant and come right back to the same situation to search a car. So obviously, the officer does not need a warrant to search a vehicle. All right. In this circumstance, it is practically impossible. All right. If this is going to be executed properly to get something unlawful that is in the vehicle. Okay, the inevitable discovery exception allows, otherwise potentially prohibited evidence to be used if the state or the federal government can prove that it would have been inevitably discovered regardless. All right, that burden of proof is on the state or the federal government, folks. Then there's the good faith exception, all right? And that happens when evidence is allowed to be used, even though the circumstances were somewhat checkered. All right, because the officer himself, him or herself, acted in good faith. That could be from a bad warrant, lacking any probable cause, or the officer searching the police database, arrested and searched and arrested the wrong person and found something on them, from a legitimate database. That evidence could still technically and possibly be used against them, depending on the circumstance. In the law, folks, there are two words which pretty much can answer any question. They are as follows. It depends. And in that, certainly with respect to the Fourth Amendment, each and every situation, it depends. It depends on what's going on, how it began, how it went about from beginning to conclusion to decide how it will end. All right? And so that's the good faith exception. As long as the officer acted in good faith in doing his or her job, if they search the wrong person, arrest the wrong person, and find something, these type of things as evidence could potentially be used against that individual because the officer acted in good faith. And last but not least, the exigent circumstance exception. All right. And this, of course, as it suggests, when the situation is, immediate and requires immediate attention, such as a fleeing felon. All right. You see someone getting assaulted. All right, you see evidence getting destroyed. The officer may have the ability, quite often, from whatever he gets from these situations, in getting evidence, to use it against the person without requiring a warrant. All right, so these are the primary exceptions to the warrant requirement, folks, under the Fourth Amendment to the Constitution, which requires a warrant to typically search or seize persons and property. So if you have any questions or controversies, leave them down below and I'll be happy to answer them. Remember, this is educational information, not legal advice. Any specific legal questions on how you should go about something, direct to an attorney. Any questions about the history or what I've mentioned in this video, you can ask me. And if they're too legally technical, I'll direct you towards an attorney. Thanks so much for listening. Hope you learned something from this video. As always, Professor Shelton.